On the 1st of April, Palestine became the 123rd state party to the International Criminal Court's statute. In fact, the International Criminal Court opened an examination into the Palestinian situation in January after Palestine submitted also a declaration asking the court to look at all crimes committed on Palestinian territory since 13th of June 2014, which is also the date for the Commission of Inquiry's investigations of the recent offensive on the Gaza Strip. The court is currently looking to receive information about any and all international crimes that may have been committed by any nationals on Palestinian territory, and Palestine, as a new state party, is committed to facilitate and cooperate with the court. It's a very important development given that Palestine over the last 2 to 3 years has somewhat politicized the role of the court and used it as a bargaining chip. So it is hoped that now, as a state party, the role of the court will be considered, as it should be, one of rendering the basic service of justice to all peoples without discrimination. So there's no way to stop the examination at the Office of the Prosecutor, which is ongoing, and there's no way to use it as a bargaining chip. Palestinian officials have said that they will ask the court to pause or suspend the examination if settlements are, construction of settlements is frozen, or for other reasons to go back to the negotiation table. The Office of the Prosecutor has started the process that it is required to undergo by the Rome Statute, and it will continue that process because it was given the jurisdiction to engage in the examination. That jurisdiction cannot be taken away unless, indeed, Palestine withdraws its signature altogether to the statute, or alternatively, the Security Council adopts a resolution unanimously with all veto-holding states that asks that the examination be deferred or suspended for a period of 12 months, which is renewable. Of course, that's a very difficult task. What the Office of the Prosecutor will essentially do in first order is look at the situation as a whole and examine its gravity, whether it's serious enough, which shouldn't pose a problem. It will look at both sides, Israeli and Palestinian violations on Palestinian territory. It will look at the national investigations and prosecutions by both sides. And here, with regards to complementarity, which is the principle at work, Israel has initiated several processes of inquiry and specific investigations into cases during the last offensive in the Gaza Strip, and more generally into political decision-making, which is unprecedented. But the problem with Israeli practice is that it doesn't accept the application of international law. And that indeed cannot change even in the specific investigations. The court will have to look at the way Israel applies and understands international law and whether it is willing to do so genuinely. And that's certainly not the case. The examination at the Office of the Prosecutor is expected to take quite some time and potentially up to a decade, given previous experience. In the meantime, all information should be provided to the office transparently and to the extent possible by government officials, including by civil society. There are some cases that are open and shut, like the settlements and the Gaza blockade. In others, including those that occurred during the recent offensive, Israeli non-cooperation can present a significant barrier to investigation as well as to prosecutions. What's important in the meantime is that some of the heat that's on the office and the court is taken off. And in that regard, Palestinian representatives and civil society should look to also activate other accountability mechanisms, including those that became available with the statehood bid, UNESCO, the UN human rights system, and others, and interstate enforcement processes with regards to third-party states involved in relations with Israel.